Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. We have a great show for you today. First, more delays for the Bryan Kohberger case. The judge takes a few more swings at the Delphi defense attorneys. Alec, Baldwin, and the prosecution want the armorer, Hannah Gutierrez, to testify on their behalf. Will she? Michelle Troconis, she got sentenced, and our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, everyone. You know the drill. Subscribe if you haven't, like if you do, leave me a comment, hit that little bell for notifications, and yes, that matters. That matters. Somehow YouTube manages to kick everybody off of getting notifications, so please hit that little bell again, please. And remember, you can listen to us anytime on any of your favorite podcasting apps. Well, today is Tuesday. We are back in the Crime Talk studios. We went to CrimeCon last week. Then I was in North Carolina yesterday, got back late last night, and now we're back at work. Anyway, we never stop working for you. And so tonight, live, 6 p.m. Mountain Time, we will begin our show. And immediately following that, that's right, our Patreon show. So if you haven't become a Patreon, now would be a good time to do that. We have lots to talk about. We can talk about the Karen retrial that continues and continues and continues. That will never end because I don't think we can do more than about 4 hours of trial testimony on any given day. And of course, we had the Chad Daybell death penalty phase complete Saturday. So we can definitely talk about that as well as anything that you want to talk about. We will take your questions and maybe we'll even, put up the call-up line as well. All right? So join us tonight, 6 p.m. Mountain Time. Let's go ahead and open the record for June 4th, 2024. And first on the docket, more delays in the Bryan Kohberger matter. Okay, what's the delay now? Well, there's been a stipulation. Stipulation just is a fancy word for an agreement. And there's been an agreement between the defense and the prosecution, and the court has rubber-stamped it, and it said that they are going to agree to a continuance of the motions hearing regarding the change of venue. And so the court has gone ahead and made that ruling, and that hearing will now be set for August 29th. Now, because it's a hearing, the prosecution wants everything, so the defense has to disclose by July 22nd what their expert is going to be testifying to. And then the state has until August 12th in which to submit what they are going to rely upon in regards to their motions hearing, and any reply by the defense is due by August 19th. Yes, the games go on and on and on. It used to be you set a motions hearing and you went for it. You showed up. Everybody did what they were supposed to do. I get it. It's a whole new world out there, ladies and gentlemen, but that's the way it is. Anyway, what is the reason for the delay? Well, the defense expert, remember him, Dr. Edelman? He was the one that was told to stop by the judge in this case, because the prosecution said he was tainting the entire process. And then the judge said, okay, I guess you didn't taint the entire process. But that delay has now caused this delay, and Dr. Edelman is requiring at least 6 more weeks to complete the surveys, to do the analysis, and basically write up his report. Now, if only the prosecution and the court had not jumped the gun and stopped Dr. Edelman, I guess we wouldn't have this delay now, would we? Well, maybe, but I think they had a little something to do with it. Anyway, for those who are not familiar with the case of Bryan Kohberger, he is accused of killing 4 University of Idaho students, and there was a hearing last week where witnesses testified about the collection of evidence and cell phone data. Well, the defense attorneys have accused the prosecution of not turning over all the evidence is in the discovery or should be in the discovery. The defense has said, we get discovery given to us like we are in a snow globe, is how they described it to the judge. Anyway, the first witness called was Moscow police detective Brett Payne, and he testified last week that thousands of hours of surveillance video were collected as part of this investigation. The detective said that the police have about 70 nine businesses' videos, and that's thousands of hours related to the investigation. And the defense lawyers also were asking whether any cell phone data is missing. And the detective had some good answers and some not so good answers because he didn't know or he didn't think so or wasn't sure because he just collected it, but someone else may have it. Then the defense called their expert witness, their cell phone guy, the Cy Ray guy. He's the former Arizona police detective, and he has a company which specializes in cellular geolocation mapping. And he testified that 2 to 3% of the cell phone data in this case is missing. But he says that some of the most significant location data in the case, that's the problem. The 2 to 3% that's missing is the most important stuff. He noted that he needs all the AT&T source data and other information for him to pinpoint exactly where Mr. Kohberger's phone was at the time of the murders. And because of the piecemealing of the data that's coming in, and because of the missing data, because of the data that he's reviewing, it's incredibly inaccurate, and there are things that are missing that is absolutely beneficial to the defense right now. And Mr. Ray testified that there are other reports that are missing that he can't tell you if it's going to benefit Mr. Kohberger or the prosecution. Now, the prosecutors allege that Kohberger is obviously the masked man who entered the house on November 13th, 2022, where 4 undergraduate students were killed by knife wound, even though we haven't been told officially. There was a K-bar. It's a knife. Anyway, no date for a trial has been set, and all we have is now the new date on August 29th. Next, the judge in the Delphi case just cannot help herself going after the defense. We can certainly talk about this tonight as well on our live program. So Judge Frances C. Gull, nope, you can't make that stuff up, ladies and gentlemen. She will not recuse herself from the case surrounding the Delphi homicide, which alleges that Richard Allen is the murderer of Abby Williams and Libby German as it relates to the killings that took place back in February of 2017. Now, as you may recall, the Indiana State Police announced Mr. Allen's arrest back in October of 2022, more than 5 years after the teens were killed. Now, since his arrest, the case has been bogged down. Let's just put it that way. Now, defense attorneys have filed a motion for Judge Frances C. Gull, who's been appointed by the Indiana Supreme Court to oversee the case after the original judge stepped down, to recuse herself from any of the proceedings. Now, it's the third time that they've attempted to have the judge removed from the case. The state's highest court, which took the issue up on appeal from Allen, when Gull attempted to have his defense team removed from the case, declined to dismiss Judge Gull from the proceedings. A motion to disqualify has been filed again back in October of 2023. Well, after that, the defense filed a motion in January of 2024 to have the judge recuse herself from those proceedings. Once again, she denied that motion. And then the second attempt to remove her was in a February 7th ruling. Well, back in May, the defense filed another motion to disqualify the judge, and she responded with a 6-page order filed on Monday addressing several issues brought up by Allen's defense team. Ultimately, she denied the motion. Judge Gull called the defense team's claim that she treated the prosecution more favorably than the defense unsupported by any admissible evidence, and noted she's handed down adverse rulings to both sides throughout the case. I'm going to have to think about that. What was adverse to the prosecution as of yet? Let me think about that a little longer, Judge Gull. Anyway, the judge said the defense blamed the court for ex parte pleadings that were inadvertently directed to the state, but those pleadings, Gull explained, were marked confidential by the defense staff, making them available to the state but not to the public. Those communications should have been filed as ex parte. And Gull said that adding that the court emailed the defense a tutorial on the proper filing process. Well, that one is probably on the defense. Let's be honest there, ladies and gentlemen. You got to follow the rules and make sure you click the right button when you file something. Anyway, the defense has claimed that the court treated its motion differently from those filed by the prosecution, and the judge noted that she scheduled hearings on some recent motions but had to delay the hearing due to the defense's filing of motions to disqualify her from the case. Each time the defense files a motion, she explained, the state is entitled to file a response within 20 days. The court noted I've issued adverse rulings against the defendant as well as against the state. Adverse rulings do not support a reasonable basis for questioning the court's impartiality, nor are they grounds for disqualification, as they are just adverse rulings. I think the judge is kind of right on that one too. Just because you don't like the judge and they rule against you doesn't mean they're wrong. And if that were the case, nothing would ever get done, because every time everybody lost a motion, they would just file a motion to recuse the judge. Anyway, the judge also responded to allegations that the defense would not be given enough time to present their case during the trial. And then on March 6th, as you may recall, the defense filed a motion for a speedy trial. The judge granted that motion, moving the proceedings from October up to May of this year. And then on April 30th, the defense requested a pretrial hearing, which Gull scheduled for May 7th. The defense, the judge notes, didn't indicate before the May 7th hearing that Gull's timeline for the trial was inadequate, with Allen's defense concerned it wouldn't have enough time to present their case. She noted, at no time prior to May 7th did the defendant indicate a belief that 3 additional weeks could be added or would be added to the trial without notice to the court, witnesses, and more importantly, without notices to the potential jurors. She did concede, however, the delaying the trial until October was harmful to the defendant, and that the state, she did concede, however, delaying the trial until October was harmful to the defendant and the state, but said the continuance could have been avoided if the defense had brought up the trial length prior to that May 7th hearing. Always the defense's fault, ladies and gentlemen. Remember that. If something gets delayed, it's always the defense's fault. I'm not joking with you, all right? That's the way they look at it. It's always the defense. Anyway, the defense attorneys noted in their motions that they've never been told a trial would absolutely end on a certain date and not go any longer. Gull called that assertion irrational and unreasonable, writing that judges around the state routinely give trial dates that begin on a set date and end on a set date. Gull went on to say that the court is not required to guarantee equal time for the prosecution and defense, and it is, however, required to guarantee sufficient time on the calendar and sufficient notice to the jurors and the parties to present their cases, however long it takes. Once again, had counsel notified the court within days of receiving the March 7th, 2024 order setting the case within speedy trial there in May, that the time allotted on the calendar was insufficient, the court would have immediately rectified the situation and extended the trial from mid-May through mid-June. Trial is now set for October 14th through November 15th of this year. Now, the judge has also responded to defense claims that the court denied reasonable requests for funding, calling that completely incorrect. She said the court was well aware of the amount of money authorized for the defense, and the court has asked the defense to submit proper invoices and bills for funding. Some of those invoices were returned because they lacked appropriate documentation, the judge wrote. She described a $26,000 invoice for investigation services that had no documentation with it, she noted. The documentation was later submitted, and the court authorized that payment. The defense, the judge notes, claims that the public confidence in the case has eroded. The judge responded and said, as counsel should know, criminal cases are tried in a court of law, not in the court of public opinion. An independent judiciary requires the judge decide cases according to the law and the facts without regard to public clamor or fear of criticism. The judge noted that she has received and sent to all parties emails and messages from the public criticizing the court, both personally and professionally, and threatening the court with bodily harm and injury for the way she has handled the case thus far. She is aware of social media memes and said the court cannot be swayed by inappropriate and ridiculous outside influences. Now, the defense alleges bias by the court in denying requests to allow cameras in the courtroom, but judge noted, hey, we did that back in October of 2023. That was the day that Gull announced that the Allen defense team planned to step away from the court, and basically the court was the one that lost trust and confidence in the videographers in the courtroom because they could not follow her rules. So there you go, ladies and gentlemen. It's always the defense's fault. Remember it, know it, learn it, take it to the field, laminate it. It'll save your life someday. it's always the defense's fault. It's not like the prosecution was completely not prepared to proceed to trial, but that's okay. It's always the defense's fault. Anyway, next on the docket, Alec Baldwin. As you may recall, Alec Baldwin is charged with the death of Helena Hutchinson, specifically charged with involuntary manslaughter. The motion to dismiss was denied by the defense. And now, guess what? Prosecutors are asking the court to ask the person that they prosecuted, the armorer, Miss Hannah Gutierrez-Reed, to testify for the prosecution in the case against Alec Baldwin. Now, it is Miss Gutierrez who apparently inadvertently, according to the jury, put live ammunition into the prop gun that Alec Baldwin was holding when it discharged on the set back in 2021, killing Helena Hutchinson and injuring the director, Joel Souza. She was convicted of involuntary manslaughter and is serving an 18-month prison sentence. Now, Mr. Baldwin faces the same sentence. Can you imagine if he were to get convicted? I wonder what would happen if Alec Baldwin got convicted. Somehow I'm guessing he would not go to prison for 18 months, but I guess we'll just have to wait and see. Anyway, Mr. Baldwin has insisted and argued that he never pulled the trigger and did not know the gun contained live ammunition. Now, Gutierrez, who has filed her notice of appeal, has appeared on witness lists for both Baldwin and the prosecution. Now, Baldwin named Ms. Gutierrez as a witness so his counsel can obtain potentially exculpatory information, according to the motion filed by the prosecutors in this case. But during a pretrial interview, Ms. Gutierrez-Reed asserted her Fifth Amendment privilege as to all substantive questioning, right? She still has a Fifth Amendment right against self-incrimination because an appeal is pending. What if it gets reversed on appeal? Guess what? She doesn't want those statements to come back and be used against her. So how is the prosecution going to get her to testify? The prosecution can ask that she be given immunity, which means that anything that she says in that trial, if she was forced to testify, could not be used against her in any future case against her. Limited use immunity. But the court has to grant it. They have to show some compelling need. And it's forced. It's not like Ms. Gutierrez-Reed can say, nah, I don't want to do it. If the judge grants her immunity, then she has to testify. If she doesn't, she faces contempt. Now, I've seen this work out both ways, where somebody gets immunity and then they will testify truthfully, or they'll say, hold me in contempt. Send me to jail for 6 months because that's all I have is contempt for this particular court. That could potentially happen. Then the question becomes, is she unavailable? The prosecution can't then just introduce her statements because, that's right, it hasn't been subject to cross-examination under Crawford v. Washington and that pesky confrontation clause. The state doesn't have the same right of confrontation, but it's not like the defense can then just say, here's her statement, she's unavailable, allow in hearsay evidence. It's hearsay. So, for the defense to get it, the prosecution needs to get it as well, so to speak. Now, can the defense ask the court to grant immunity? It doesn't usually work that way, at least not anywhere I've ever practiced law. The prosecution holds the keys. They file a motion with the court saying we're going to grant immunity. The court orders it. The witness must testify. If the defense says, I need this witness to testify, I want to give them immunity, if the prosecution objects, then it is not done. So I'm not sure which route Miss Hannah Gutierrez-Reed will take, but I don't think I'd want to help anyone in this particular situation. Why would you want to help the prosecution that helped, throw you under the bus? And then why would you want to help Alec Baldwin because he's throwing you under the bus? I wonder if Mr. Baldwin or his people helped with your attorney's fees. Ooh, that's right. Big issue, right? That's why, ladies and gentlemen, by God, defendants have to stick together. The old United we stand, divided we fall. That's the way it is. Mr. Baldwin, obviously looking out for himself, and that's why everybody has separate attorneys, but had everybody said, we're going to stick together, we're going to lawyer up together, don't worry about it, I'll take care of your legal fees there, Miss Gutierrez-Reed, we're on Team Baldwin, this may be playing out a little differently. That's for sure. And do you think everybody down there in Santa Fe is going to know that Gutierrez-Reed has already been convicted? Oh, yes, they are. Yes, they are. So I can't wait for this trial to begin. It's not that far away. I got some good news on the plane today. We could go down there rather quickly. I think it'd be about a 45-minute flight. This is going to be a circus. Or maybe Alec Baldwin will take a plea deal. We'll have to wait and see. Anyway, you know who should have probably taken a plea deal way back in the day? That's right, Michelle Troconis. A judge sentenced Miss Troconis to 2 decades in prison, but said, hey, 14 and a half years ought to be enough for your involvement in the 2019 death of Jennifer Dulos. Now, a jury found Miss Troconis guilty back in March of conspiracy to commit murder, 2 counts of conspiracy to commit tampering with physical evidence, 2 counts of tampering with physical evidence, and hindering the prosecution. A judge vacated one of her charges of the conspiracy to commit tampering with physical evidence. And like I said, Troconis initially faced up to 45 years. She got 20. She'll do 14 and a half, probably serve 50%. She'll be out in 6-7 years, ladies and gentlemen, if not more, with additional earned time credit, good time credit, you name it. So we'll just have to wait and see. But hey, she's got a dead body on her hand and she's only going to do probably 7 years. Not that I'm saying you should go harm anybody, but let's face it, that's not that long a time. Now, I certainly wouldn't tell Ms. Troconis, run from Photos Dulos if she had asked me for advice, but they never asked me beforehand. They always come to me afterwards and say, fix the problems that I have created for myself. And finally today, our dumb criminal of the day. Please meet Mr. Ryan Howard. The problem for Mr. Howard is, and why he became our dumb criminal of the day, well, first, dumb. He was spray painting a wall in St. Petersburg, Florida. Okay, can I tell you, graffiti, it's the scourge of the community. Everyone that does graffiti should have to clean it all up, okay? So that was his first problem. But when the police first made contact with Mr. Howard, what did they see? Well, they saw the spray paint cans that they observed in plain view, and they asked him, hey, who are you? And Mr. Howard said, well, my date of birth was April 20th, 1969. Get it? 4/20, 1969. Anyway, he also said that his name was Mr. Monopoly. Interesting choices for sure. Anyway, he was ultimately identified through a driver's license that he had from the state of Maine. He was charged with resisting arrest, a misdemeanor, providing a fake name and date of birth, on top of the criminal mischief, of course. But you were lucky, Mr. Monopoly, a.k.a. Mr. Howard, that it was only a misdemeanor. Some jurisdictions, they would charge you with a felony for that. That's right, attempting to influence a public official. Good thing you got off the way you did. All right, that's all we have for you today. Thanks for watching. Please join us tonight, 6 p.m. Mountain Time, for our Tuesday night live program, immediately followed by our Patreon show. Have a wonderful day. We'll see you tonight. And remember, that's right, the Constitution matters.